And he was asking if he needed to be here at drug court. I was thinking he had to be at drug court. I told him here.
That's his problem. He should know where he is. He's supposed to know where he this. I'm bewildered. I don't know which court I'm supposed to be in. Doesn't bind me. Well, here's somebody.
Yes. Come up here.
The state is ready on this case, Judge.
You can't make this stuff up. You can't make this stuff up.
I know that.
Let me ask you. You're Joseph Thibodeau? You're set for trial today.
Today?
Yeah, you're set for a trial today, sir. Don't act like you're bewildered. Yeah, you've got a theft case. It's almost 1,000 days old. Yeah. Well, and you come to court in a t-shirt. That's the best you've got to impress everyone about how important these proceedings are. Okay, what are you wearing it for then? To humiliate the court? What is it that you're wearing? Would you wear that to church? Why not? Why wouldn't you wear it to church? You got the cross out. That's which generally, unless you're using them as jewelry, that's kind of worn next to your heart. Not on the outside, but that's I guess your idea of but what are you wearing a t-shirt for here in court? My goodness. I mean, it's a felony court. You can go to prison, a prison facility, It's a felony. Really, I sound like I'm scolding you like I'm your mother or something. But I mean, are you an adult? You are an adult. How old are you? 25. You don't look like you appreciate the proceedings here and the importance of it. Yeah, I wouldn't. Why didn't you come in with a swimsuit? I mean, that would have been the next logical thing to wear. Good Lord. Look at everybody. Everybody's serious. These are important things. Most importantly, it's for you. I'm railing this. And I have to say it. It probably doesn't do any good, but it just has to be said because there's just seems to be a lack of appreciation of the importance and the respect in certain functions nowadays. And you're Exhibit A. I hate to say, but really, nobody. Look at everybody. Look at everybody. You see anybody dressed like you're on the way to a clam dig?
Well, Zelensky dressed Congress in a t-shirt.
I'm not even talking to you. Can I see your driver's license? See, that's what you don't even have a driver's license.
Saying no respect. But we're ready if you want to send it to drug court. Keep it here.
Ronald Tyler.
I'm
tired. Railing on. It's just howling at the moon. The moon will come back up tomorrow. Coyotes still howl. Ronald Tyler. It's Gertz.
Yes, Judge.
Mr. Gertz. Yeah.
Mr. Tyler is present. He's outside, Judge. I would ask for
Who's on that?
It's Mr. Offpower, but I'll stand in, Judge.
I'd ask for just an additional resetting in this case.
What do y'all say?
He's an older gentleman and has had a bunch of health issues.
Who hasn't?
He's a lot.
Is it?
I had health issues this
Older
morning.
than you, Judge.
No. But what do y'all say?
I trust Mr. Gertz. If he needs the time, I'll give it to him.
Thank you.
I actually said that on the record.
There's one person, yes, typed that. He actually said my name with that too. So
I did.
No pronoun.
It'll be reset.
I said Mr. Gertz, so it could be your dad. Yeah, it could be your dad.
That would be reset.
Thank you.
Okay. Darius Stevenson, Mr. Burbank. Darius Stevenson. He's in jail. I'm looking at this probable cause today, and the defendant admitted this. Is that right?
Yes, Your Honor. He admitted to being in possession of the motorcycle that was used in the robbery.
It's not a complaint. It's complaint said. It says confirmed loaning his motorcycle to Oscar LeBlanc, who admitted to robbing a female at the gas station.
Correct.
Well, I mean, so he is the one who admitted
Yes.
to somebody.
Yes,
I don't know who.
the actual owner of the motorcycle, he had made the admissions to him that the motorcycle was used in a robbery. And it was in response to
Oh, okay.
tips that were out there looking for that motorcycle.
When's the earliest we're gonna be able to try this thing? What do you think? I mean, you're going through with this,
A month is fine.
sir,
A month is fine.
sir?
A month is fine.
A month, 4 weeks, okay. We're gonna reset it 4 weeks, just have a seat, before you leave.
Request me to ask you, you could modify his condition of taking off the GPS. He's had no violation since he's been out. The case has been pending. I think it costs him $300 something a month.
Hold on, let me get the state's lawyer up here to be heard. Lonnie Rogers, they're asking for a bond condition amendment.
Yeah, I think he's home confinement. He's at work. He wants to see, he said maybe an alternative would be a curfew judge. See his kids.
They can't come see him. Here is all of this.
55 days.
Move forward. Oh. There you go.
He does not have a vehicle, even judge. He does not.
Okay. Go ahead. I'm familiar with this now.
Since he's been out, he's had no violations, Judge. He is on unlimited income. He's living with his family. He would ask that the GPS be removed. He has no problem with the curfew. He can only leave the house on necessities. But he does have family that he'd like to see. Ask that he be allowed so he doesn't have to pay the GPS fee. And allow him to just have a curfew.
Let me ask a question here. The 2009 conviction. What was the circumstance of that? What happened in that? It says accident involving injury or death.
Judge, I have to look at what was you put your this was a car wreck. It was a car wreck. No.
Is there a complaint in that by any chance?
A PC.
Yeah.
Yes.
Well, okay.
This is the probable cause. You want me to read it to you, or do you want to look at it?
Real fast, thank you. Minor injuries. Here's the problem is, number one, he's a habitual felon, number one, right? He's looking at 25 to life. That first felony conviction in 2009 that I know about was a vehicle where you struck a vehicle and you fled, it's alleged, and then you were later convicted of the crime. The next is aggravated assault out of Galveston County. What, do you happen to have anything about that second conviction in 2000? I'm sorry, that's the first one. It's paragraph number 2, but it's the earliest of what I know. He was convicted in Galveston, and then 6 years later, it is alleged he committed this accident involving injury in 2009 in Jefferson County that he was convicted of. But the aggravated assault, what did that involve?
I don't have it, Judge.
Yeah. Do you have a pin pack or something like that?
I'm looking, I'm seeing form was scanned in. Oh, I'm in the wrong case. Let me get the other case.
It's Lonnie
The
Rogers.
pending case, yes, sir. No, pending.
38880.
I was looking at the old accident involving injury or death. Let me get. I should have it.
I know.
Oscar LeBlanc, did you get a resetting already? Get a resetting and you're free to go. Yeah.
Well, he's good to go. I told him.
He's good to go?
Yeah,
Okay. Bye.
you're good to go. Yes, I've already here.
Okay.
See a scanned in document, Judge, yet.
Uh-uh.
I'm still looking.
I don't do more.
Is there a
Yeah.
a pin pack or a
That's what I'm looking for.
Judgment.
That should be scanned in, but I don't see one.
Okay. I just gotta. I'll sit up and say.
No, there's not one.
PDC or state judge? 2 years state, PDC. judge.
do you know what the circumstances were about that case?
Up to judge. Yeah, it was a fight case that I didn't call, maybe I don't call that, so I didn't know that he goes to it. Well, you did, what you said you did, it was a 911 case? Sure. No, I said it, I didn't call. But there was a fight. 2 years, what were the injuries? Sure. Got to go to the hospital. Yes, sir. And how did they go to the hospital? Besides ambulance? Was there a wound? Broke now? There wasn't any weapons involved? No stabbings, no shootings? Broke nose? In 2 years? 2 years. How much time did you actually do in 2 years? I don't know. So I got like 4 months. 4 months, 2 years.
Anything?
Just, no, with
That's
his,
not in there?
no, sir. With his prior record though, looking at just the habitual.
I mean, you don't get convicted for not calling 911 for an aggravated assault. That's not what is the element of the offense. There's something else involved. But the problem is what we have is a accident involving injury or death for which you were convicted. What was the sentence on that case? That first one? I'm sorry, the one in 2009.
2 years.
Then aggravated assault in 2003, you were convicted of. And then now we have second degree felony of manslaughter where an individual was killed in this event. So you've got two cases, one pending, one conviction for injuries or death involving a motor vehicle you were operating. Then there's an aggravated assault that we're still uncertain about what the circumstances were there, but it's nonetheless a second degree of an assault of some sort. So now we have this case with manslaughter, and
Would the court consider lifting the necessity requirement
for what?
and allowing him to move around freely with the GPS?
The no. Number one, the GPS is not gonna get released, because how can we prevent you from hopping in a car and doing something again?
No, I'm not
We
asking
can't,
for it.
oh, your attorney asked for it, but that request is denied. We want to know where he is at all times. And if he's driving, if he operates a motor vehicle, his bond will be revoked immediately when I learn of it, and there's good cause to believe it. And then you will sit out in jail until we can try this case, because there's just the last 20 years have been dangerous for others with you, according to the indictment. Then the next thing is, I'll allow him to go for work, to and from work, to and from the store to get food. But he can't get in a motor vehicle. Somebody's going to have to operate that, or he's going to have to walk or something like that. But other than that, but it's the necessities that the court will allow in the most direct route to and from. And you have to call your bondsman and tell them and alert them that that's going to happen. But no, you're not free to amble about like others, because of the circumstances of this indictment. And to me, this is not a hard one to analyze. Next time something happens, if it did, it would be shame on whoever was.
I wasn't asking to drive, I was just asking because it's.
I'm sorry, your attorney asked to release you from the GPS device, and the GPS is, you're gonna speak for me?
Sorry.
The GPS is kind of a check and balance to make sure that if you do drive, we know about it,
Right.
and then shame on you. But how do we, somebody is not hired to keep an eye on you.
See?
So the only other way we have it realistically is to monitor you is through a GPS. And that's what is being done.
It would be excused, Judge.
Yes,
Thank you. And you'll be subject to
sir.
on the trial, now he was on the trial.
Yeah, so I think we had something, he's not in custody, but I had some cases that I had set, and I think that was including him in the event. Just one of the other courts open up.
Just call us.
Call Mr. Reynolds and Mr. Franklin, just tell them to be on standby in the morning. Is it the morning? We're picking it here this afternoon, Joe. This afternoon. Okay, 22-40682 is now called the state of Texas versus Byron James Harmon. You're Mr. Harmon, present with your attorney, Mr. LeBlanc, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary? Yes, sure. In summary, this indictment alleges in paragraphs 1 and 2 is, I think, all we're going on.
That's correct.
Paragraph 1 alleges that on or about January 25th, 2022 in Jefferson County, Texas, you committed the offense of operating a motor vehicle in a public place while you were intoxicated. Paragraph 2 goes on to allege that on 2 or more occasions, I'm seeing 2 occasions here articulated, that on April 11th, 2011 and on March 24th, 2016, You were convicted out of County Courts at Law number 2 of Jefferson County, Texas, and County Court at Law of Orange County, Texas, respectively, in those cases, with the offense of operating a motor vehicle while intoxicated, DWIs. So 2 or more prior convictions of DWIs with paragraph 1 constitute a third-degree felony. Do you understand what you were charged with? What had happened here, it looks like in October, we started a hearing on this, and then that was because I wrote true on here 10 / and that's all, something happened. So we were here before to plea, and then that plea hearing ended without a plea.
That is correct, Judge.
This is a third-degree felony. If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement has been reached where you would be pleading guilty, sentenced to 5 years in prison. Is that your understanding of the agreement? If I follow this, you have no right of appeal. You understand? How do you plead to paragraphs 1 and 2 of this indictment, guilty or not guilty? Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty? Also, paragraph 2, which alleges those prior convictions. Do you have some white out? Real quick. Yeah, thank you. Are you pleading true to those convictions of DWIs in 2011 and 2016? I gotta erase this more. And are you pleading true to those allegations in paragraph 2 voluntarily, knowingly, intelligently, and because they are true as they are alleged? I'm going to show you what's marked as State's Exhibit 1. Here, did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents all true and correct? State's Exhibit 1 is tendered into evidence without objection admitted. Among other things, the states you are mentally competent to enter your guilty plea and pleas of true, which are freely and voluntarily made. You know what you've been indicted for. The indictments have been read to you. You've read them. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Is that so? State's Exhibit 1 is made a part of the record for all purposes. Without objection.
No objection.
It's admitted. I need blue pens. Roll ball, please. Just have blacks and reds. Don't worry about it, but I need one. Yeah, I'm gonna use this felt. All right. If nothing further to add, I'm going to find you were pleading guilty today and true to paragraphs 1 and 2 respectively, constituting the third-degree felony of operating a motor vehicle in a public place while intoxicated with 2 or more prior DWI convictions. You were doing that voluntarily, knowingly, intelligently. There's sufficient evidence supporting your plea of true to paragraphs 1 and 2 here, this third-degree felony, to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in this offense. I'm following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. Do you understand what has happened to those? Anything else?
No,
That's
Your
all. Bob, do you have another one?
No.
No.